Merci.
Thank you, Madam President. Madam President, distinguished members of the Court, the fourth provisional measure sought by Azerbaijan reads as follows, and it should be on your screen. Armenia shall take effective measures to collect and to prevent the destruction and ensure the preservation of evidence related to allegations of ethnically motivated crimes against Azerbaijanis of which it is aware, including those identified in communications from the Republic of Azerbaijan. By way of comparison, the request that you received from Armenia last week, which is mutatis mutandis identical to that you indicated in 2020 to Myanmar, reads as follows. Azerbaijan shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of the CERD. Aside from the fact, of course, that the addressee of the measure sought by Azerbaijan in this case is different from that you received last week because of the terms that you can see highlighted in yellow on your screen. The respective requests from the parties on evidence are not identical. In fact, as you have seen, looking at the screen, and as I shall demonstrate to you, they are profoundly different. As regards these differences, we can see from them that the measure sought by Azerbaijan must be rejected because it is not consistent with the jurisprudence of the court as regards preservation of evidence, and it does not serve to protect a plausible right under the Convention on the Elimination of Racial Discrimination. This will be the first point in my pleading. I shall then show that even limited and reduced to identical terms as those used last week by Armenia, a more limited provisional measure in terms of conservation of evidence would also be without foundation. There are a number of legal and factual reasons that can explain this, and I shall go over that in the second part of my presentation. Madam President, as a provisional measure, and as I have just recalled, Armenia asked you last week to order Azerbaijan to take all effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of any act or fact within the scope of this CERD in order to allow it to claim its rights on the merits subsequently. This request concerned the preservation of all evidence, criminal, of course, but it also covered evidence concerning inter alia Armenian cultural heritage and other violations perpetrated by Azerbaijan. This evidence to be found in Baku and in the territories under Azerbaijan control, and that is why it is for Azerbaijan to preserve the evidence. Particularly as I showed last week, Azerbaijan is currently involved in modifying, without any possible return to the status quo, elements from Armenian cultural heritage. This would be the case of Armenian churches that President Aliyev intends to restore, in other words, transform into Albano-Caucasian churches, as was the case with the provisional measure that you granted to Gambia. That sought by Armenia in terms of conservation of evidence is a complement in support of the other provisional measures sought. Azerbaijan is asking you today to do something which in fact is totally different. The measures sought in terms of collection and preservation of evidence is independent of the other measures sought, and it bears no relation to those other measures as it is specific to criminal matters. We could say that it is self-standing. It's not been added, or, to take the terms of Lord Goldsmith last week, it is not an add-on to Azerbaijan's other requests. The provisional measures sought by Azerbaijan in terms of the collection and conservation of evidence is thus different in its object and purpose from that you ordered in order to protect the rights of Gambia and that sought by Armenia last week. Thus, when you order a provisional measure on evidence, we're talking about guaranteeing their conservation and not collection. And it is always in support of other measures ordered to protect the rights at issue so that these can be claimed at the merit stage. To date, the court has never ordered a measure for the collection of evidence. And when you're ordering that evidence be preserved, it's never separate and without any link to other measures indicated. That should be enough in itself to reject the request for the provisional measures sought. However, there is another element that is even more fundamental that also constitutes an obstacle. Indeed, the measure postulated by Azerbaijan, as you have seen, is substantially different from that sought by Armenia. As I have recalled, according to the provisional measure sought, Armenia should seek to collect and ensure the preservation of evidence linked to allegations of ethnically motivated crimes inter alia because they have been notified by Azerbaijan. This means that there is a requirement that they would have to provide information concerning inter alia the possibility of prosecutions for these grave crimes, and this would refer to notifications by Azerbaijan itself. You will have seen that the request itself is highly ambiguous as to which state should thus be able to prosecute, to take law enforcement action. And Ms. Reid did not clarify the situation this morning. Azerbaijan is not asking you to order Armenia to gather and retain evidence so that Armenia itself can prosecute any possible crimes. No, it is far broader than this. And without excluding this first possibility, in a broader fashion, Azerbaijan is asking also that through the provisional measures sought, it can, if necessary, mete out punishment for the violations it denounces. It should be recalled, in fact, that Azerbaijan's application on the merits uses wording that through the wording itself and through its object as well is broad enough to include the fact that Armenia should make it possible for Azerbaijan to mete out punishment itself for these crimes. On the merits, Azerbaijan is asking that Armenia be ordered to ensure that criminal investigations can be carried out into crimes that it denounces, thus ensuring their punishment. This is what Azerbaijan is asking in its application instituting proceedings on the merits. Armenia must take all steps necessary to comply with its obligations under CERD, including to ensure the investigation and punishment of acts of discrimination, including but not limited to war crimes committed by Armenian forces, etc. The supposed right that Azerbaijan intends to protect through the provisional measures sought is as follows. The right that Azerbaijan allegedly has to require of Armenia that it take all measures making it possible for either Armenia or Azerbaijan itself to investigate the crimes denounced, to prosecute the perpetrators thereof, and to punish them. Madam President, distinguished members of the Court, such a right is not plausible under the CERD. And the provisional measure sought by Azerbaijan is not related to any right that state might claim under the Convention. In other terms, the measure sought does not serve to allow Azerbaijan to claim at the merit stage any rights under the Convention. And why? Quite simply because this convention is not an instrument of international criminal cooperation. Admittedly, Article 4A of the convention does oblige states to make certain behavior an offense punishable by law. But the convention does not organize the prosecution or punishment thereof through criminal cooperation among parties. And that is why, as regards the proceedings that were before you last week, Armenia is quite simply asking that you order Azerbaijan to cease its continuous violations of the Convention and consequently punish all acts of racial discrimination. Armenia is asking for nothing more because there's no basis in the Convention to ask for more. In reality, through the provisional measures sought, Azerbaijan is seriously misconstruing the Convention. It's an instrument to protect human rights of individuals through Erga Omnes Partes obligations, but Azerbaijan is trying to turn it into a treaty of legal cooperation containing bilateral obligations among states. But there are other procedures and other instruments that exist for that purpose, including the Minsk Convention of 1993, by which both parties are bound and which governs the legal cooperation between them, including in criminal matters. So even as a provisional measure, Azerbaijan is not entitled to require of Armenia that it gathers evidence and ensures prosecution on the denunciation of Azerbaijan, nor does Azerbaijan have any right to require of Armenia that it take all measures necessary to allow Azerbaijan to punish itself, to mete out punishment itself for the crimes that, according to it, would have been allegedly been committed by Armenia or its nationals. Such requirements would go well beyond the protection of the rights, plausible rights under the Convention. The provisional measure sought by Azerbaijan has no basis in the Convention. It does not serve to protect a plausible right thereunder, and it has no relationship with the rights that can be claimed by Azerbaijan under the Convention. This measure must therefore be rejected. Madam President, this brings me to the second part of my pleading. Can Azerbaijan claim a provisional measure that is less ambitious in terms of preservation of evidence? Admittedly, it's tempting to treat both parties in the same way and to grant to Azerbaijan in this case what would be granted to Armenia in the previous case. What is more, this is doubtless one of the main objectives behind the mirror proceedings instituted just 1 week after those brought by Armenia. However, even formulated in terms identical to those used last week by Armenia, indication of a more limited provisional measure is in no way justified here for a number of different reasons. First of all, the first reason. In its more limited wording, the measure would become an add-on measure, a measure that's not self-standing as relation to the other measures sought. As demonstrated by my colleagues, those other measures should not be indicated. What is more, an evidence provisional measure, even in its reduced form, must fail as there is no independent basis to sustain it, to paraphrase once again Lord Goldsmith. And then we have the second reason. Even if the impossible were to occur and one of the other provisional measures were to be ordered, the reduced measure concerning preservation of evidence would have no material link with any of the others. It would be, therefore, unwarranted. Third reason. In support of the provisional measure it seeks, Azerbaijan contends that Armenia allegedly did not investigate the violations of international law committed during the 1991-1994 conflict, nor those that allegedly occurred during the more recent conflict in 2020. That was repeated this morning. Azerbaijan concludes in paragraph 29 of its request for an indication of provisional measures, there is a serious risk that alleged perpetrators will flee in order to escape prosecution, that witnesses to these crimes will be unable to be located, and that evidence will deteriorate or become wholly unavailable. Ms. Reid said nothing different this morning. As for the alleged disappearance of evidence concerning the first war between 1991 and 1994, Azerbaijan's case is particularly paltry in this regard, as you will note. What is more, and notwithstanding what was said by the agent for Azerbaijan this morning, it's difficult to see how that state can accuse Armenia of failing to punish acts that allegedly occurred before the entry into force of the convention between the parties in 1996. All the more so as regards the gathering of evidence relating to those facts. The principles of non-retroactivity of treaties and contemporaneity in the law on international responsibility prevent this. Here we have a third obstacle. It is a legal one and it is insurmountable, preventing the indication of provisional measures, even in a reduced version, and concerning the events that are outside the temporal scope of the convention. In any case, distinguished members of the court, how can conservation of decade-old evidence be a matter of urgency while waiting for the court to rule on the merits? As regards the evidence concerning facts that relate to occurrences during the war of 2020, there is a certain amount of footage of abuses that have been filed by Azerbaijan. A significant number of the videos annexed between numbers 56.1 to 56.11 concern abuses and crimes perpetrated by Azerbaijani soldiers against Armenian soldiers. I have no need to recall to you that certain Armenian victims of such crimes are still being detained in Azerbaijan. And the video footage confirms that they remain in a vulnerable position. At length, Azerbaijan told you how seriously its public prosecutor was investigating crimes committed by members of its military against Armenian soldiers. Here, however, is the way in which the Azerbaijani public prosecutor talks of the videos concerning the crimes committed against Armenian soldiers and filed by Azerbaijan in this case. The sentence that you see on the screen comes from the document that is to be found at tab 10 of the file that you received this morning. It is a letter from the Service of the Public Prosecutor. Although some of the videos were found to be fake, there are serious doubts as to whether some of them are true and reflect reality. Certain videos are fake. Others are deemed to be dubious. That is how seriously the public prosecutor of Azerbaijan is viewing the evidence that he has when it concerns Armenian victims. Such statements from the service that is responsible for criminal prosecutions could, of course, be used in order to obtain acquittal of someone being prosecuted. Other footage filed by Azerbaijan seems to concern abuses and crimes committed by Armenian soldiers against Azerbaijani soldiers. I'm referring to annexes 38 to 52 in the evidence filed last week by Azerbaijan, and Ms. Reid referred to this again this morning. Contrary to what Azerbaijan appears to be suggesting, the question for you, in order to decide whether to grant the provisional measure sought, is not to decide which state is the most diligent in prosecution and punishment of crimes committed in the recent conflict, even if, as Professor Murphy said last week, Azerbaijan's record on the matter is far, very far from being convincing. As you heard this morning, Azerbaijan has made much of its supposed efforts to punish the crimes of its soldiers and always compares them to those of Armenia. This self-proclaimed moral superiority is a precise reflection of the discriminatory and anti-Armenian official rhetoric from Baku. Here, indeed, you have the word used by the public prosecutor for Azerbaijan to describe both the valor of the military of his country and the crimes committed by certain members thereof. And I refer once again to the document at tab 10 of your file of this morning. According to the public prosecutor, Respect for international humanitarian law shown by Azerbaijani armed forces is demonstrating the high culture and humanism of our people. On the other hand, when Azerbaijani soldiers commit war crimes, here is the only possible reason. It is regrettable to note that mistakes in the understanding of the methods and techniques of struggle against the enemy by some servicemen under the influence of the severe psychological state caused by the war led to committing illegal acts that could overshadow the bravery and zeal shown by the armed forces, as well as the victory gained. But why is it that these crimes are tarnishing victory? Ms. Reid said this morning that it was because these crimes were unacceptable. Admittedly, but here is the full answer of the prosecutor. If the crimes perpetrated by the Azerbaijani soldiers are unacceptable, it is because those crimes contradict the mentality of the Azerbaijani people, which is tolerant, highly appreciates multicultural values, and is historically distinguished by its humanism. In other words, no such thing is happening in Armenia. As for Armenia, distinguished members of the court, it utterly condemns the abuses committed by any of its armed forces and takes seriously its obligations to investigate and prosecute, and as regards the evidence pertaining thereto. And here I'd like to thank Ms. Reid for having referred you this morning to the communications addressed by Armenia to the European Court of Human Rights, because these clearly show how seriously Armenia takes its obligations. But, distinguished members of the court, as I've already said, you are not comparing the parties' efforts to prosecute these crimes in order to discern Azerbaijan's application. The only question is the only relevant one to see whether the factual elements filed by Azerbaijan make it possible to justify a provisional measure narrower than that requested in order to preserve evidence because of imminent risk of the disappearance or destruction of evidence of these crimes. That is not the case. This has not been established, and there are no grounds to believe it to be so. Indeed, you'll find at tab 2 of your file a certified statement from the Deputy Public Prosecutor of Armenia referring to the fact that the services have opened 6 cases for serious criminal violation of international humanitarian law during the hostilities of last year against members of the Armenian armed forces. You heard Ms. Reid say this morning that there was nothing more than that in the Armenian file. She relied on the May 2021 report of the International Partnership of Human Rights and Truth Hounds and the September 2021 report from the Parliamentary Assembly of the Council of Europe, which prepared the resolution that was rejected by all of the Azerbaijani deputies. These two institutions, and Ms. Reid as well, have clearly forgotten that in a communication of the 2nd of April 2021, in other words, before the two reports relied on by my colleague. So in that report, which was transmitted to 3 UN special rapporteurs in response to a request for information on the 2nd of February, Armenia described in further detail the 6 criminal cases referred to in the letter of the Deputy Public Prosecutor of that country. You will find the request from the 3 UN rapporteurs and the Armenian response in your file at tabs 3 and 4. These documents are public and they are available on the website of the UN High Commissioner for Human Rights. The special rapporteurs are particularly concerned about the footage of crimes in the videos annexed by Azerbaijan under numbers 38 and 52. As can clearly be seen by the communication sent by Armenia in response on the 2nd of April, the 2 crimes are the object of the first 2 criminal cases that have been opened for a violation of international humanitarian law.